For Idaho News 6, I'm senior reporter Don Nilsson. HB 500 is a law that was passed by the Idaho legislature that bans transgender women from participating in women's sports in the state of Idaho. It is held up in court known as Hecox versus Little. It is now in the Supreme Court's hand. But just last week, Representative for Lindsay Hecox, a transgender athlete from Boise State, asked the Supreme Court to drop the case. So what happens now?
I'm just another person like anyone else, and they have vilified what I'm trying to do.
That was Boise State transgender athlete Lindsay Hecox speaking with Idaho News 6 in 2020 when she became a plaintiff in a lawsuit filed by the ACLU over the passage of HB 500, a law signed by Governor Brad Little that banned transgender women and girls from participating in sports consistent with their gender identity. Hecox wanted to try out for the Broncos women's track and cross country team. But last week, the ACLU withdrew the Idaho-based transgender sports case, Hecox vs. Little, from the U.S. Supreme Court. The reason for pulling the case is that the plaintiff, Lindsay Hecox, moved out of Idaho for her senior year of college, saying the case is now moot. Not so fast, says an attorney for the Alliance Defending Freedom, a conservative group working with Idaho's Attorney General's office. They want the case to go forward.
We see this as the ACLU's really Hail Mary attempt to pull the rug out from under the U.S. Supreme Court before the court can issue a decision that we think the ACLU is afraid is going to rule against them and set nationwide precedent that the ACLU is trying to avoid.
The ACLU sent me this statement concerning their withdrawal, and I quote, "After ending her participation in any women's athletic programs covered by House Bill 500 to prioritize finishing her degree at Boise State and her personal safety and wellness, Lindsay has withdrawn her challenge to Idaho's HB 500. The Idaho Attorney General's office told me they will hold off on commenting until their briefs are delivered to the court. Former Idaho Attorney General David Leroy told me it is extremely unusual for such a case to be withdrawn at this very late stage. I asked Leroy, what now?
The U.S. Supreme Court has rules that say unless all the parties agree, a single party can make a motion to voluntarily dismiss the case. The opposing party can object within 15 days, and then it's up to the court to either allow or disallow that.
The senior counselor for ADF expects the district court will rule quickly on whether or not the case can go forward despite ACLU's withdrawal. We'll keep you up to date. Reporting from downtown Boise, I'm senior reporter Don Nelson, Idaho News 6.